If you are a green card holder who travels internationally, if you have family members abroad that you visit regularly, or if you are planning any trip outside the United States in the coming months, then the announcement I am about to share with you is the most critical immigration update you will hear this year. The Department of Homeland Security has officially confirmed a major rule change that will fundamentally alter how green card holders are treated when they try to re-enter the United States starting in 2026. This is not a rumor. This is not speculation from social media. This is a verified, confirmed policy change that could result in you being stopped at the border, questioned for hours, detained in secondary inspection, and in some cases denied entry to the country you call home. The country where you have built your life, raised your family, established your career, and invested your future. I have been a senior U.S. immigration professional for 6 years, working directly with thousands of green card holders navigating complex immigration situations. And through my work, I have made it my mission to warn you before these changes affect your life, your family, and everything you have worked so hard to build. Stay with me until the very end, because what I explain today could be the difference between coming home safely to your family and being stranded at the airport wondering what went wrong, watching your dreams of permanent residence slip away before your eyes. Let me speak directly to your heart for a moment. I know what your green card means to you. It is not just a piece of plastic with your photo on it. It is the promise of a permanent home in the United States. It is the culmination of years of waiting, sometimes decades of patience, thousands of dollars in fees and legal costs, and countless hours of paperwork, interviews, and anxiety. It represents stability, opportunity, and the American dream you worked so hard to achieve. When you received your green card, you believed rightfully that you could live, work, and travel freely as a lawful permanent resident of the United States. You believed that your status was secure, that you had finally achieved the stability you sought. And now, when you hear that DHS has confirmed green card re-entry could be stopped, your first reaction is probably fear. Deep, unsettling fear. Fear that you will be trapped outside the country while your life continues inside. Fear that you will lose everything you have built, your home, your job, your community. Fear that the rules have changed without adequate warning, without giving you time to prepare. Fear that one wrong decision about travel could cost you everything. I understand that fear completely. I talk to people like you every single day, people who are worried, confused, and desperately seeking answers about how to protect their permanent resident status. But today is not a day for panic. Today is a day for preparation, for understanding, and for taking control of your situation. Because this rule change is coming, it is real and it is significant. But if you understand it clearly and follow the right steps, you can continue to travel internationally and return home safely to the United States without jeopardizing your permanent resident status. As of today, the Department of Homeland Security has officially confirmed a new enforcement framework for green card holder re-entry that will take full effect in phases beginning in early 2026. This confirmation came through official DHS policy guidance released in coordination with U.S. Customs and Border Protection and has been widely reported by major news outlets including Reuters, the Associated Press, and the Wall Street Journal. This is not coming from unofficial sources or immigration forums. This is verified, official policy that is being implemented as we speak. The core of this change is a dramatic tightening of how CBP officers evaluate whether a green card holder has abandoned their permanent resident status based on travel patterns, time spent abroad, and evidence of ties to the United States. This represents a fundamental shift in how the government views what it means to be a permanent resident. The emphasis is now heavily on the word resident, meaning someone who actually resides, lives, and maintains their primary home in the United States. Under the current rules, which have been in place for decades and which many of you have relied upon, a green card holder who leaves the United States for less than 1 year is generally presumed to have maintained their permanent residence. Trips longer than 1 year require a re-entry permit, and trips longer than 2 years typically result in automatic loss of status. While CBP officers have always had the legal authority to question travelers and challenge their intent to maintain residence, The enforcement has historically been somewhat flexible, especially for people who could explain extended absences due to family emergencies, work assignments, or other legitimate reasons. Many green card holders have traveled frequently under these rules without any issues whatsoever. That flexibility is now ending. Under the new 2026 framework, CBP officers will apply a strict 180-day threshold for enhanced scrutiny. Let me be absolutely clear about what this means. Any green card holder who has been outside the United States for more than 180 consecutive days, that is roughly 6 months, will automatically be flagged in the computer system for secondary inspection upon arrival at any U.S. port of entry. This is not random. This is not discretionary. This is automatic. During secondary inspection, which can last anywhere from 30 minutes to several hours, the officer will review your complete travel history going back multiple years, examine evidence of your ties to the U.S., including tax returns, employment records, property ownership, and family connections, and make a determination on the spot about whether you have abandoned your permanent residence. This is not a casual conversation. This is a formal interview where every answer matters. If the officer determines that you have abandoned your residence, you will be given a choice, and neither option is pleasant. You can voluntarily surrender your green card right there at the airport, or you can be placed in removal proceedings before an immigration judge, which means you will be allowed to enter temporarily, but will have to fight to keep your status in immigration court. But here is the part that is truly alarming for many green card holders, and this is where the new rules go far beyond anything we have seen before. Even if you have been gone for less than 180 days on your most recent trip, you can still be stopped and questioned if your cumulative travel pattern over the past 3 years shows that you have spent more time outside the U.S. than inside. The new system includes an automated tracking algorithm, a computer system that calculates your total days abroad versus total days present in the United States based on entry and exit records that are now fully digitized and tracked. If your ratio falls below 50% presence in the U.S. over a rolling 36-month period, you will be automatically flagged regardless of the length of your most recent trip. This is a complete game changer. This means that even if each individual trip you take is short, if the cumulative effect is that you are spending most of your time outside the United States, you are at risk. Let me give you a concrete example to show exactly how this works in practice. Imagine a green card holder who lives in California but frequently visits elderly parents in the Philippines. Over the past 3 years, this person has taken 8 trips, each lasting about 6 weeks, totaling approximately 336 days abroad. This person has also spent all of the remaining time, about 760 days, in the United States, working, paying taxes, and maintaining a home. Under the old system, this individual would likely pass through customs without any issue because each individual trip was well under 1 year, and there was clear intent to maintain U.S. residence. Under the new 2026 framework, this person's 69% presence ratio means they are above the threshold and should be fine. They are spending more than half their time in the U.S., which demonstrates genuine residence. But imagine another green card holder who splits time between New York and a business in Colombia. Over 3 years, this person has spent 600 days abroad and 496 days in the U.S. The presence ratio is only 45%, meaning less than half the time is spent in the United States. When this individual tries to re-enter in 2026, they will be flagged automatically, pulled into secondary inspection, and will be asked to prove that they have not abandoned their permanent residence. If they cannot provide sufficient evidence, which includes tax returns showing U.S. income, a U.S. residential address with supporting documentation, utility bills, employment records, family ties, health insurance, vehicle registration, they could lose their green card on the spot. No appeal, no second chance. Just an immediate determination that the officer makes based on the evidence presented. Now, I want to address some of the most common questions I have been receiving since this announcement was confirmed, because I know many of you are wondering about specific scenarios. The first question is, does this mean I cannot travel at all? The answer is absolutely no. You can still travel internationally, but you must be strategic, thoughtful, and careful about how long you stay abroad and how you document your ties to the United States. The new rules do not prohibit travel. They punish travel patterns that suggest you are not actually living in America as your primary residence. There is a big difference between taking vacations and family visits versus living primarily abroad. The second question is, what if I have a legitimate reason to be abroad for a long time, such as a family emergency? The new rules do include provisions for documented emergencies, such as caring for a critically ill family member. But the burden of proof is entirely on you. You must have documentation, including medical records, death certificates, legal documents, proving that your extended absence was unavoidable and temporary. Simply saying you had a family emergency will not be enough. Work assignments abroad are much more complicated. Unless your employer is a U.S. company and you have a formal assignment letter stating that you are temporarily working abroad on behalf of a U.S. employer, extended work-related travel may not be sufficient justification under the new standards. The third question is, what if I already have a re-entry permit? Re-entry permits remain valid and will still allow you to stay abroad for up to 2 years without automatically losing your status. However, and this is absolutely critical to understand, the new rules add a layer of scrutiny even for re-entry permit holders. When you return to the United States, CBP officers will still evaluate whether you have maintained genuine ties to the U.S., and a re-entry permit alone will not guarantee entry if your overall pattern suggests abandonment. The re-entry permit prevents automatic loss of status, but it does not prevent questioning or a finding of abandonment based on lack of ties. So, what should you do right now to protect yourself? Let me give you 5 concrete steps you can take today to safeguard your permanent resident status. First, calculate your travel ratio immediately. Gather your passport, or all of your passports if you have renewed during the past 3 years. Look at every entry and exit stamp for the past 3 years and add up your total days abroad versus days in the U.S. If your presence ratio is below 50%, you need to take action now. Consider staying in the U.S. for an extended period to rebuild your ratio before the new rules take full effect in early 2026. Second, gather and organize documentation of your U.S. ties. This includes your most recent 3 years of U.S. tax returns. And you should be filing taxes even if you earn income abroad, because U.S. permanent residents have a tax filing obligation. Also, gather your lease or mortgage documents, utility bills in your name, bank statements from U.S. accounts, employment records, health insurance cards, vehicle registration, driver's license, and any evidence of family members living in the U.S., such as marriage certificates or children's school records. Keep copies of all of this in a dedicated folder that you carry with you every time you travel internationally. Third, if you know you will need to be abroad for more than 6 months, apply for a re-entry permit now before you leave. The processing time for Form I-131 can take several months, and you must be physically present in the U.S. to submit your biometrics. Having an approved re-entry permit will give you an extra layer of protection under the new rules, even though it is not an absolute guarantee of entry. Fourth, if you are a frequent traveler with a borderline presence ratio, consider consulting with a qualified immigration attorney before your next trip. An attorney can review your specific situation, help you document your ties properly, and advise you on whether you are at risk of an abandonment finding based on your individual circumstances. Fifth, do not panic, but do not ignore this either. The worst thing you can do is assume that because you have had no problems in the past, you will have no problems in the future. The rules are changing fundamentally. CBP officers will be applying stricter standards, and the consequences of being wrong are severe and potentially permanent. Let me share another real-world example that illustrates exactly why preparation matters. I recently worked with a green card holder from Egypt who has had his green card for 15 years and has always traveled freely between the U.S. and Egypt to visit family. Over the past 3 years, this individual spent about 550 days abroad, mostly caring for an elderly father who passed away last year, and about 546 days in the U.S. The presence ratio was 49.8%, just barely under the 50% threshold by a matter of days. When this person returned to the U.S. last month, they were pulled into secondary inspection. The officer asked a series of detailed questions about ties to the U.S., employment, residential address, and reasons for being abroad. Because this individual had prepared thoroughly, bringing copies of tax returns, apartment lease, father's medical records and death certificate, and a letter from an employer, they were able to demonstrate that there was no intent to abandon residence. They were allowed to enter after about 2 hours, but they told me afterward that it was the most stressful experience of their life, and they had never experienced anything like it in 15 years of international travel. This is the new reality for green card holders. This is what is coming in 2026. I know this is a lot to absorb. I know it feels overwhelming and perhaps unfair that the goalposts keep moving. But I want you to understand something important. You are not powerless. You have time to prepare. You have tools to protect yourself, and you have access to information that can keep you informed every step of the way. As we come to the end of this discussion, I want to remind you of something crucial. Knowledge is protection. The fact that you are reading this right now means you are already ahead of millions of green card holders who have no idea these changes are coming. You are taking responsibility for your future, and that is the most powerful thing you can do. If this information helped you understand the new green card re-entry rules taking effect in 2026, please share it with every green card holder you know. Knowledge shared is knowledge multiplied, and together we can ensure that people are prepared rather than caught off guard. Before I go, my standard disclaimer. Everything I have shared today is for general informational purposes only. It is not legal advice. Immigration rules are complex and change frequently. Your individual situation may have unique factors that require professional guidance. Please consult with a qualified immigration attorney for advice specific to your case. Always verify information with official government sources, including the DHS and CBP websites. Policy can change, and the information I provided is accurate as of today. Thank you for trusting me with your time and your future. You have worked too hard for your green card to lose it because of a rule change you did not know about. Together, we will make sure that does not happen. Stay safe, stay informed, and take care of yourself and your family.